No, so give me about it. This is just so many things are just come down here so that we can make for the first part of the show. That's great. The whole process. Show up. You can have just for the beginning.
Good evening, ladies and gentlemen. Hello. Strangely enough, this is a council meeting. It's a different configuration, and I just asked Brian, why is this a council meeting? It doesn't have to be, although we've always done our training as a council meeting. And we do have actually a bylaw to pass tonight after this information session is over. There will be a bylaw on to confirm the by-election process. The council, if you're not keeping up with current affairs in Sioux, you've been looking more nationally. At the council meeting last week, we decided on the option. It was either appointment to fill the vacancy on council or by-election. And council has decided to have a by-election. So there's a very formal process legislated by, as most things in Ontario, governed by the province that we do. And we have to pass a bylaw tonight, and then for 60 days from now, the
maximum is 60 days. Yes.
Maximum 60 days. So that's going to happen. So bear with us. There'll just be 3 minutes of formalities to get the council meeting started, and then the focus will be on the screens. And I'll give it over to Brian to run the show until that training is over. And I think actually the timing, the training. I asked Brian another question. Every council term, this is my second, and Councillor Timpson, you've had this probably 3 or 4 times. We do the training, the conflict of interest training for council and committees and boards. And I think it's timely because if you follow current affairs, this morning's news at Thunder Bay, it's been ongoing for some time, but 2 city councillors in Thunder Bay had an integrity commissioner complaint against them for conflict of interest, and the integrity commissioner found that they were both in conflict of interest. It wasn't financial; it had to do with a bylaw, a zoning application, and their, let's say, interference in the process or in terms of council's decisions. So it's timely that we do this. It's always good to keep ourselves up to date. The laws do change as well. So I'll call the meeting to order at 6:10 p.m. Introduction of amendments to the agenda.
Through you, Mayor Lawrence, I have none.
We have a motion to confirm the agenda for the October 22nd council meeting. Councillor Lego, seconded by Councillor Cassidy. All in favor? Confirmed. Declarations of pecuniary interest.
Through you, Mayor Lawrence, I have none.
Are we sure?
I haven't received any. That's all I can say.
So at this point, I'm going to introduce, I'll let the clerk introduce the delegation and turn the meeting over to the clerk. And the council wants to move to another seat to look in a different direction, feel free to do so. I'll see how fine the print is.
Thank you very much, Mayor Lawrence. Good evening, everyone, and welcome. Thank you so much for taking a couple of hours out of your very busy schedules to attend this evening's presentation. We're very fortunate to have joining us this evening Megan Barrett, who is a lawyer with Aird and Burles LP, and who is also Sioux Integrity Commissioner. Aird and Burles have a very excellent reputation throughout the province in providing integrity commissioner services, and we were very fortunate when we went out to RFP that we were able to select them for Sioux Lookout, and that was a decision council made last year. So this evening's presentation, Megan will be speaking about our code of conduct, the code of conduct that council has adopted, which every municipality in Ontario must now have a code of conduct. And she will also speak a bit about the Municipal Conflict of Interest Act. So Those are the sort of the two handouts that you have. In the folders is stuff that we can talk about later or at another time. It's it's a copy of the terms of reference for whichever board, commission, and committee you serve on. There's sort of a declaration that we'll ask you to sign once you've had an opportunity to review all the material, just sort of saying that yes, you've reviewed it, you understand it, and so on and so forth. And that's again just so that we can demonstrate we're doing our due diligence, and part of that is providing this training. As you look around the room, as you probably know, we have between 80 and 100 members of our community who are very, very generous of their time, like you, who volunteer on various boards, commissions, and committees. Obviously, not everybody could attend this evening. So we are actually recording this presentation. I think I mentioned that to you, Megan, I hope. Surprise! So it will be available for other community board, commission, and community volunteers as the need arises. Again, Megan, I will turn things over to Megan. She's an absolutely delightful person. I had the opportunity to meet her here in Sioux Lookout a number of months ago. She was visiting a friend in Sioux Lookout, and so we had that great opportunity to meet and have lunch. And I will now hand the presentation off to her. Thank you.
Thank you, Brian, and Mayor Lawrence for that great introduction. Can everyone hear me all right? Can I see nodding? I can see you. I know you can see me. I can see you too. Okay, great. This is my first time doing this training session over Skype or whatever we're using right now. So if there are any technical glitches, if someone who is facing the front of the room can put up their hand, and then we can sort it out, including your ability to hear me. I am very excited to be giving this training session to you. As Brian said, I had the great pleasure of visiting your beautiful municipality in April and got a little tour, so that was very fun. And now I'm happy to be with you here tonight, and I thank you for your time. Sometimes it's hard to get people to come to a presentation by a lawyer. It's like not a big selling feature often. So thank you for coming and giving up your Tuesday evening to spend this time with me. So I am going to divide tonight's presentation into two parts. The first part is going to be about your code of conduct and about codes of conduct generally, and integrity commissioners and their roles and their function. The second part of the presentation is going to be about the Municipal Conflict of Interest Act. And as Mayor Lawrence alluded to, there have been some changes with respect to the municipal accountability regime in the Municipal Act, and also changes to the Municipal Conflict of Interest Act. So some of this stuff is new. In between those two sessions, I am going to give you a short break because I would like to keep your attention. So I think we can plan to probably have a 10-minute break between that. So just so that everyone knows how this presentation is going to go. First of all, let's talk about the Code of Conduct. As of March 1st of this year, codes of conduct are mandatory in all municipalities. Up until then, municipalities could adopt a code of conduct, as you did in your municipality in 2012, but weren't required to do so, nor were they required to appoint an integrity commissioner. So this is a new system that we are dealing with. Your code of conduct, the version that's in force right now, was adopted on March 20th by bylaw 3119, and I think you have a copy of that in front of you tonight. We're going to actually walk through some of the key provisions or highlight some of the provisions in that code of conduct to make it more exciting to read through, hopefully. So what is a code of conduct? Codes of ethics in the public sector are intended to promote integrity in public affairs and to provide guides to acceptable behavior. Codes are reference points for public servants. As well, they are tools for the public to view government actions. They provide a set of standards by which the public may judge government action or evaluate the action of officials they have encountered. So a code of conduct is not meant to be an encyclopedia or a cookbook of every possible breach that could occur. It's meant to be interpreted. And that's why we're doing this training session, to understand how to interpret that code of conduct a little bit better. A code of conduct, though, on its face should be credible, useful, and functional, which means that it should hopefully be understandable by members of council and members of local boards and by members of the community. And I think that despite the fact your code of conduct was written by lawyers, I do think that it's one that we've at least tried to make readable and understandable. So there are 4 mandatory subject matters that must be included in every code of conduct. Those are prescribed in OReg 5518, and they are, first of all, gifts, benefits, and hospitalities, which tends to be a hot topic. So if you are offered a gift, benefit, or hospitality, I urge you to be wary and make sure that you're reviewing the provisions related to that in your code of conduct. A second prescribed or mandatory subject matter are policies that deal with respectful conduct, including conduct towards officers and employees of the municipality or the local board. So one example of that, or something that's now mandatory, are council staff relationship policies, and I'm sure you have that in force at your municipality. Confidential information is a third subject matter that needs to be covered. That, of course, would include documents that you receive at a closed meeting. The use of property in the municipality or of the local board, and that includes both personal property or property as you like a concrete object, but also intellectual property. So be cognizant that things like official marks or logos of your municipality count as property, and we'll talk a little bit more about that in a moment. So your code of conduct for Sioux Lookout covers all of these 4 mandatory provisions, and it's a credible and comprehensive code of conduct. Now, the mandatory subject matters that are cited in the legislation, or the regulation, tells us what needs to be included in the code of conduct, but not necessarily how to address these matters. So that's what's set out in your code of conduct. And here I'm going to actually walk through the code of conduct a little bit with you. So if you have it in front of you, that would be helpful. Starting with section 1. Starting with section 1 of the code of conduct relating to the application and purpose of the code. Your code of conduct applies to...
I just interject for one quick second. I just want to make sure everyone can find it. So it's on the right-hand side behind the agenda. There's a bylaw there with the code of conduct attached to it. So that's the document we're referring to. Sorry, Megan, thanks.
No, thank you. That's very helpful. And I also should say, while everyone is searching through their papers, that I forgot to mention at the outset that if anyone has questions, I encourage you to interject. We'll test out how this works via Skype. I can see most of you, I think. So I do encourage you to ask questions as they come up, being mindful, of course, of the fact that we need to get through this material in 2 hours. So if there are too many questions, I may cut them off a little bit, but hopefully we can have a little bit of a discussion about some of these matters. So if everyone has the code of conduct in front of them, just wanted to highlight, first of all, the application and purpose section of the code, which applies to all members of council, including the mayor, and unless specifically indicated, with necessary modifications to all of the members, of all of the municipalities, committees, agencies, boards, and commissions. So what does apply with necessary modifications mean? I would encourage you, I think the way that you can interpret this is to apply a common sense interpretation when you're reading the code of conduct. In some cases, it's going to be very clear, and that's certainly what we will be doing as integrity commissioners if we're interpreting any complaint. So in some cases, it's very clear when a code of conduct provision would not apply to a non-elected member. So for example, if it's any sort of provision dealing with an election campaign or during an election period, that wouldn't obviously apply to a member of a local board. There are other provisions where the application might be a little bit more nuanced. So for example, there's an obligation in the Code of Conduct to recognize that the reputation, sorry, let me just pull it up, that the member is a representative of the municipality and that they owe a duty of loyalty to the residents of the municipality at all times. If you're a member of council, we would interpret this in a more this would be applied in sort of a more strict sense than if you're a local board. There's more recognition that you're a volunteer if you're a member of a local board than if you're a member of council, where the expectations about your conduct and your being a face of the municipality or face of council is a little bit different. So that's just one example. It's not cut and dry, but certainly we would be looking at the circumstances of the case and using a common sense approach to that. This is typical language to have the same code of conduct apply to both members of council and members of local board. And this type of provision is typical. So 1.2 of the code of conduct sets out the purpose of the code, which is to establish a general standard to ensure that all members share a common basis for acceptable conduct. That mimics or is in line with the quote that we read earlier from Gregory Levine about what a code of ethics should be. So that's set out actually in your code of conduct. This section of the code also references other pieces of legislation that govern your actions as members of council or of local boards. Section 2 of the Code of Conduct sets out the statement of principles. These are sort of, I'm going to call them motherhood statements that are not operative provisions of the code. The purpose of having a statements of principles like this, and we'll see them as well in the Municipal Conflict of Interest Act, I'll point them out to you. The purpose of having these statements of principle is to help understand, apply, and interpret the other operative provisions of the code. So no one can tell me that or allege that you contravened these statements of principle, but it's something that I will look to guide my interpretation and judgment on a matter. Section 3 sets out certain definitions. I'm not going to read all of them. The ones that I wanted to highlight for you on page 3 are conflict of interest, which in your code of conduct is defined in a way that's different than a conflict of interest under the Municipal Conflict of Interest Act. We'll talk about this later tonight, but under the MCIA, a conflict of interest is narrowly defined as being only related to financial matters. Under your conflict of interest, it's a bit broader. And then F, I'd like to also draw to your attention, council is defined, references to council in the Code of Conduct are defined to include council, but also to be interpreted with necessary modifications to the committees, agencies, boards, or commissions that many of you represent. So just so that you're aware, and then I'll commend the rest of those definitions to your reading. Section 4 sets out general obligations in the Code of Conduct. These are operative provisions, so everything moving on are things that can be the subject of a complaint. I'm not going to read through all of the general obligations, but some of the key obligations that you have as a member is to make every effort to act with good faith and care, seek to advance the public interest with honesty, refrain from making statements known to be false, for instance, and that one that I read earlier, recognize that you're a representative of the municipality and you owe a duty of loyalty to the residents of the municipality, turning the page, accurately communicating the decisions of council. You're not, after the fact, misrepresenting what actually happened at your meeting to a member of the media, for instance. So those are sort of I mean, I didn't read all of them, but those are the general obligations. Section 5 speaks to the role of staff. I've noticed as I've been across the province doing this little road trip training sessions, that this is a provision that we include in our codes of conduct. They're included in most, or something similar to this is included in most codes of conduct that I've seen. And they talk about, and the provision is that as an individual member, as you know, you can't act individually. You only have authority to act as council. And so this provision of the Code of Conduct highlights the fact that as an individual member, you yourself do not have the authority to direct or oversee the function of staff of the municipality. And this can be a tricky one, and we've certainly had complaints related to these types of issues. What is the role? What is your role, especially as a member of council? I noticed that a lot of council members who have been very long-standing have a more hands-on, or can have a more hands-on role with staff in the municipality. That is something that would contravene this section of the Code of Conduct. So please just be aware of that. I'm pointing it out to you in particular. And similarly, 5.2 directs that any inquiries of staff from members should be made or should be directed to the CAO or to the appropriate senior staff member. So that's actually in your Code of Conduct, and I just want to draw that to your attention. Section 6 deals with municipal property. You must not use or permit the use of the municipality's lands, facilities, equipment, supplies, services, staff, or other resources for activities other than the business of the municipality, sort of a standard provision. Section 7 sets out the policies related to gifts and benefits. 7.2 sets out sort of a general rule that you shall not accept a gift or benefit or lots of other things that are similar unless you fit into one of these exceptions that are set out in 7.2. And one of the important ones there that I just want to draw your attention to is the monetary value of gifts, and that's the limit of $300 for value for a gift. 7.3 sets out a process if you are receiving a gift that meets one of those exceptions, that you need to file a disclosure, and that disclosure statement is actually included with your Code of Conduct in that same package as Appendix A. Section 8 deals with confidential information. Again, pretty standard. You shall not disclose confidential information. Oh, and now I have to figure out how to turn the lights back on. I'm so sorry. Please just give me 1 second.
They must not have paid the fine for building it.
My apologies. That we did not test for earlier today. I knew there'd be something. That wasn't too bad. Let's hope that's the only thing. Where were we? Section 9 sets out the policies on discrimination and harassment. Again, that's the type of policy that you would expect to see in a Code of Conduct. You have an obligation to treat all members of the public, one another, and staff with respect and without abuse, bullying, or intimidation. Section 10 deals with improper use of influence and states that a member shall not use the influence of their office or appointment for any purpose other than the exercise of his or her official duties in the public interest. And this isn't just your, like in terms of your benefit, it's also a benefit of your family, your friends, or your associates. So it extends to that piece. Section 11 relates to conflicts of interest. I'll point out in 11.1 speaks to both complying with the obligations in the MCIA and also imposes an obligation to mitigate any non-pecuniary conflicts of interest, so non-monetary or non-financial conflicts of interest in order to maintain public confidence in the municipality and its elected officials. So one of those would be related, likely if we saw some sort of complaint, we would see a complaint that if it's monetary, relates to money, we'd see it in 11.1 being cited in the complaint, and then we would also see a complaint under the MCIA. Whereas if it's a non-monetary issue, then it would only be 11.1 and the MCIA would not be engaged. We'll get into that in more detail in a moment. I just wanted to give you a little overview. Section 13.1 relates to election activity and states that you need to conduct yourself in accordance with the Municipal Elections Act and your municipality's policies relating to elections, and also states that the use of municipal resources, both property and staff time, is strictly prohibited for election-related purposes. Okay, so those are kind of the substantive sections of the code. Well, I think actually 14 is also important, and I want to draw this one to your attention. You have an obligation to respect the process for complaints made under the Code of Conduct, and an obligation to not act in reprisal or threaten reprisal against a person who makes a complaint or provides information to the Integrity Commissioner during an investigation. And you have an obligation to cooperate with requests for information during any investigation. So let's talk for a moment about the complaint protocol. The complaint protocol is part of the statutory scheme together with part 5.1 of the Municipal Act, which is where we get our statutory authority to do all of these things, and the Code of Conduct, of course, respecting the enforcement of Code of Conduct complaints. So the Code of Conduct itself gives you sort of the substance, and the complaint protocol gives you the process in this case. The complaint protocol sets out a process and procedure for how a complaint must be filed or submitted, and how a matter will be considered and possibly investigated. So your complaint protocol is set out in two parts. The first provides for an informal process, and during the informal process, the Integrity Commissioner may or may not be involved. And then there's a secondary part B, formal complaint process, where a formal complaint in writing is filed. And there are certain requirements set out in the complaint protocol for complaints. So the first requirement is that the complaint must be in writing in a prescribed form. So there's actually a form attached to the complaint protocol that needs to be filled out. This form needs to be dated and signed. The complaint itself needs to set out reasonable and probable grounds to support the allegation. And if we receive a complaint that we don't think has sufficient information, we have the ability to go back and ask for additional information or clarification. We also have the ability to dismiss complaints, and I will talk about that shortly. And then finally, the complaint itself must be in the form of a sworn affidavit. And in this case, that's really important, I think, because this isn't just a willy-nilly going to dash off an email sort of situation. This is a legal document, and you're swearing to the truth of the contents of the allegations that are contained in the complaint. I believe Brian has the ability to commission the affidavit, or you can go to someone else who is a commissioner for affidavits and can do that. A lawyer, for instance, would be able to do that for you. So council also has the ability to file a complaint. So it could be a member of the public, it could be another council member, or it could be council itself that's filing the complaint. And an elector has the ability to request that the Integrity Commissioner investigate a contravention of the Municipal Conflict of Interest Act. So it can be under the Code of Conduct or the MCIA. So the complaint protocol, in addition to setting out all of these form requirements, which is the first thing that I will look at upon receipt of a complaint. Also sets out the grounds under section 5 under which I can refuse, or an integrity commissioner can refuse to conduct an investigation. And so just based on the complaint received on its face, a determination can and is made relatively frequently that the complaint is frivolous or vexatious, that it's not made in good faith, that it constitutes an abusive process, it discloses no grounds or insufficient grounds for an investigation, or it does not warrant a full investigation. And in some cases, there may just be, it may be a legal question and there are no legal grounds to advance the complaint. And that I will provide to you in writing and explain why the complaint is being dismissed. Section 7 of the complaint protocol sets out the timelines and process for the actual investigation that takes place. So if you want to understand what's happening, this is where you should be looking. So the process here is that we would receive a complaint and then provide the member who's the subject of the complaint with an outline of the complaint. But I need to tell you that there is no obligation on me to disclose to you, the member, the identity of the complainant or the identity of any witnesses that are set out in the complaint, unless I determine that it's essential for the member, for you, the member, or whoever the person is, to adequately respond to the complaint. And there is case law supporting this authority. So a copy of the, or an outline of the complaint will be provided to the member. The member then has 10 days to respond to, or to provide a written response to the allegations in the complaint. And then that copy of the member's response will be provided to the complainant, who then has 10 days to respond. So these steps for procedural fairness are built into the process so that everyone has an opportunity to have their say if an investigation is commenced. And of course, there is the residual right that we retain to extend the timelines if required. Okay, I'm not going to go through all of the complaint protocol, but you certainly can take a look through it. If you have any questions, let me know. The other thing that I wanted to highlight to you was that once a report, after there has been an investigation, Integrity Commissioner prepares a report. That report is received by council in public. The name of the complainant is not included typically in the report, but the report does mention the name of the council member or a local board member. Okay. Oops. So I'm going to move on now and talk about the role and function of integrity commissioners. Integrity commissioners are a statutory officer who report directly to council. We are not beholden to anyone at the municipality. We derive our authority from statute in the Municipal Act, from your code of conduct, your complaint protocol, and the principles of natural justice and procedural fairness, which are key principles in administrative law, and they're kind of what you'd expect, making sure people get their day in court. And I mean, I say that it's in my office, behind a computer, we're not actually in court. But just so that you have your opportunity to be heard in a way that's appropriate in the context. So that's built into the system. Integrity commissioner exercises his or her functions independently, and the functions of the integrity commissioner are assigned by the municipality with respect to the code of conduct and the MCIA, and that's set out in your accountability framework bylaw that was passed by council. So the functions that have been assigned to us are to advise council or members to prevent violations before they happen, educate members on their responsibilities and obligations, investigate complaints and conduct inquiries, adjudicate complaints, and recommend penalties or corrective or remedial measures that be imposed if there's a contravention found. So just to be clear, it's not the integrity commissioner who is imposing penalties, it's only council who can impose a penalty. The integrity commissioner is recommending that a certain penalty or remedial measure be imposed. So the role, so is anyone familiar with the Bellamy report? No, a little bit of too nerdy of a reference. Okay, how about the Y2K scandal in Toronto? Do you remember, like back in the day, way back? Okay, yeah. Thank you, that person who just put up their hand. Now I feel like I'm in a real room. Okay, so the Y2K scandal back in Toronto, big deal about computer leasing. The Bellamy report is an extensive document that investigated and then reported on this scandal that occurred in Toronto. And it is sort of the mother document that we integrity commissioner, or started this idea of integrity commissioners, or had some good general principles. Recommendations that were contained in the Bellamy report are still things that we're talking about and are slowly getting implemented today. It's also a great read, I got to tell you. Like it's written sort of like a novel in some places. There were lots of interesting people stories happening there. Anyway, the Bellamy report provided or stated that an effective integrity commissioner system provides two basic services. The first is an advisory service to help counselors and staff who seek advice before they act. And as I said, this is now something that's in place, almost 15 years later. And secondly, an investigative or enforcement service to examine conduct alleged to be an ethical breach. So in some cases, it may seem a little counterintuitive to have an integrity commissioner give advice and then also investigate. And there are some municipalities where there are different integrity commissioners who have those two different roles. Like in the city of Ottawa, they have two separate integrity commissioners, but in most cases, it's actually the same person. And that's envisioned in the statute, and it's also was part of the recommendation in the Bellamy report that we look at. So as of March 1st, 2019, municipalities that have not appointed an integrity commissioner are required to make arrangements for all of the responsibilities of an integrity commissioner to be provided either by their own integrity commissioner or the integrity commissioner of another municipality. And if you've appointed an integrity commissioner and not appointed all of the functions, then you need to figure out a way to make those functions available. So you, through resolution CL 09319, passed a resolution to appoint Erda Burles as your integrity commissioner with those functions. So that's great. The functions of an integrity commissioner were expanded. Like in addition to requiring that every municipality have an integrity commissioner, the changes to the act that came into force on March 1st also expanded the role of an integrity commissioner. So the function or the text that's in red here are the things that are new. So applying and enforcing the code of conduct and other ethical policies or guidelines, that's something that integrity commissioners have always done. But applying and enforcing the Municipal Conflict of Interest Act, that's new. Providing written advice to members regarding their obligations under the Code of Conduct and the MCIA, that's also new. Before, some municipalities had a stipend available for members to go and seek external legal advice. from their own personal lawyer, but not every municipality, and obviously this could be a big expense. Now you have the right to go to your own integrity commissioner, me, to seek advice. I should say that this is not a blank check. I am a lawyer and I do charge by the hour. So be cognizant of that, but it is certainly a resource that's available to you and you have a right to access. And hopefully after this training session, you'll have a clearer idea of what some of your obligations are. And frankly, we get a lot of questions about MCIA obligations. And I found with some members after, you've had one or two questions, which tend to be from real estate agents, like all the time, I don't know, then you maybe have a better understanding and get a feel for what could be something that you have an obligation for and not. But we'll talk about the importance of including the facts of each individual case in writing to me if you're seeking advice. Because it's important to have all of the information. If I don't have all of the information, my advice is not something that you can rely on. I digress. The fourth function of the Integrity Commissioner is to provide educational information to members of council and local boards, which we always had a role to do. But now that function has been expanded to also be to provide information to the public. And so this is an open council meeting, as I understand, and this would fulfill that obligation to provide education and training to members of the public. So integrity commissioners are statutory officers of the municipality, and so are immune from liability as long as they act in good faith under Section 448 of the Municipal Act, like other statutory officers. But there's another specific indemnification requirement in Section 223.3 of the Municipal Act that requires municipalities to indemnify their integrity commissioners as long as they're acting in good faith as well. All right, so I alluded to this a little bit earlier, so I won't spend too much time talking about this, but the Integrity Commissioner's advice-giving function relates to advice on the Code of Conduct, any ethical policy guidelines or procedures, and sections 5, 5.1, and 5.2 of the MCIA. The advice must be requested in writing by the member and provided in writing by the Integrity Commissioner. And the reason why everything needs to be in writing is because as the member, you are entitled to rely on the advice as long as all relevant facts have been provided and you follow the advice that's given. So I'm going to give you an example of that when we are talking about the MCIA, but just be aware that everything needs to be clear and needs to be there from your perspective so that you can rely on the advice that I'm giving. But of course, you need to use your judgment a little bit because it's not a chapter book. It's just making sure that the key facts. So I'll give you an example in the second part of the presentation. So the Integrity Commissioner's investigative powers are on a complaints-based process. Council has the authority to request that an Integrity Commissioner investigate or research a matter. The Integrity Commissioner does not have their own innate authority to act on his or her own volition or initiative, which I am happy about. Originally, when the changes were proposed that came into force on March 1st, the province had been suggesting that the Integrity Commissioner would be able to initiate investigations on their own initiative. That's a kind of power that I don't really want, frankly. So that was removed. I believe that was at the request of Integrity Commissioners because, like, what would that even look like? In any event, that's not there anymore, so it is based on complaints. The code of conduct and the complaint protocol sets out the terms for an investigation or an inquiry, and we went through some of those terms. You're welcome to go look at that in the process in some more detail. So the investigative powers that are granted to the Integrity Commissioner are set out in section 223.4 sub 2 of the Municipal Act. That grants the Integrity Commissioner the authority to exercise the powers under sections 33 and 34 of the Public Inquiries Act, which means that the Integrity Commissioner has the authority or the power to issue summons and subpoena information. So there's an obligation in your code of conduct to cooperate with the Integrity Commissioner, but there's also a right or an authority under the Municipal Act that lets us make you do that. Subsection 3 of this section provides the municipality shall give the Commissioner such information as the Commissioner believes to be necessary for an inquiry, and states that the Commissioner is entitled to have free access to all records that are deemed to be necessary for an inquiry. So I was involved in an investigation with a school board where we didn't actually have these powers because under the Education Act, there are no such broad powers for an Integrity Commissioner. It's a different system. In that case, we were investigating an allegation against a trustee that the trustee had released confidential information to the media, and then it was this whole big hullabaloo. And it involved an extensive investigation where we needed to interview many members of senior staff who had allegedly heard this leak from one of the trustees. We had the complaint named the trustee that they thought was the source of the breach. So we were able to reach out to that trustee who thankfully cooperated with us and allowed us to do a scoped search of her emails in that period. And there was evidence, or there wasn't evidence in those emails to support the allegation. And so, but we were able to verify by doing that search of the email to corroborate the statements of the trustee. So in her case, it actually helped her out to be able to say this, it's just not there. So we were able to actually look at her emails and confirm that. But of course, under the Municipal Act, in this context, the Integrity Commissioner does have the authority to require disclosure of that type of material. In terms of the Integrity Commissioner's obligations during an investigation, there is a duty of confidentiality that applies to the Integrity Commissioner and every person acting under the instructions of the Integrity Commissioner to preserve secrecy with respect to all matters that come to his or her knowledge. I think that this is akin to solicitor-client privilege, and it's a statutory obligation for confidentiality. Subsection 3 relates to, or just explains that the information that is the subject of an Integrity Commissioner's investigation, the records that we produce, etc., they are not subject to the rules under MFIPA because these records are not considered information that would be in the municipality's coffers. So that's protected from that regime there. If a matter comes up in an investigation that relates to another type of matter, so for example, a criminal code matter, then, or a workplace harassment matter, for instance, then the Integrity Commissioner has the obligation to refer the matter to the appropriate authorities and suspend the investigation pending the investigation by the other authority. In terms of judicial guidance on how to do our jobs as integrity commissioners, we look at to the divisional court's decision in what we call the DiBiase case. This case is important because it was the first judicial review of an integrity commissioner's investigation and report under a code of conduct in Ontario. It was the subject of this case. It was a judicial review application brought by Michael DiBiase, who at the time was the deputy mayor and a regional councillor in the city of Vaughan. And the application was to quash or request to quash a report of the integrity commissioner. The report related to a complaint that the deputy mayor had received a benefit from a named contractor and had assisted the contractor in various attempts to obtain city business, and that the deputy mayor had voted improperly in matters that were before council related to this contractor. So what happened in this case in terms of the investigation, just so that you can see an example, the integrity commissioner received the complaint. She then forwarded a copy of the complaint to the member, whose lawyer then responded on his behalf, which it can be the member, you yourself as the member can respond, or you can retain a lawyer to respond. That happens, both of those scenarios happen. In this case, a lawyer responded. The lawyer had lots of arguments against the complaint, including allegations that the complaint had been filed by a political rival. That's something we hear a lot. The integrity commissioner in this case received the response from the member, decided nevertheless to investigate some of the allegations in the complaint. So two of the allegations were the subject of her investigation. The first was with respect to improper interference with the tendering process in assistance of the contractor. And the second related to the deputy mayor's various attempts to exercise influence to the benefit of the contractor. There was also an allegation regarding an improper relationship between Councillor DiBiase and the contractor. But that matter, the integrity commissioner determined was of a criminal nature. And so that part of the investigation she hived off and sent or referred to the police to investigate. But she continued on with the rest of her investigation. She made a number of findings, including that the councillor had violated the city's code of conduct by swearing at and bullying staff who would not hand over confidential information about city bids to him. He'd emailed confidential city information to an outside source, and his reply, or the outside source, this contractor's reply to the councillor had actually copied and pasted that reply into emails to his fellow councillors and staff. So he was being directed behind the scenes by this third party. The integrity commissioner also found that he had undertaken acts with a view to exercising influence or assisting the contractor to secure city business. So these were the findings in the report that went to council. Council accepted the report and recommendations and voted to suspend the deputy mayor's pay for the maximum, which was 90 days. And that's where the appeal happened once that decision was made by council. And so the matter went to the divisional court, was considered by, I don't know if I have his name. I don't have his name. By a judge at the divisional court who clarified that an integrity commissioner is conferred a broad discretion with respect to its investigation and investigative process. And that's important to understand, and upheld the process that had been followed by the integrity commissioner in this case, including her choice to not disclose the name of the complainant and also not disclose the name of the witnesses who had provided information to her. So some of the things that the divisional court said an integrity commissioner could do in this case and in generally moving forward is decide when to investigate a complaint and when to not investigate a complaint, whether and how to reformulate a complaint received, a decision to undertake a targeted email search on a municipal system, which is what occurred in this case, and as I said, withhold disclosure of certain witnesses' identities. So that's just one example and also a court case that walks through sort of the process for an investigation. And that's something that we look at and when we're trying to understand what our powers and our duties are as integrity commissioner. So in terms of enforcement of the code of conduct, the way this works, first of all, there are two different reporting requirements for the integrity commissioner. The first is a periodic report to council, and this is a report that sets out a summary of the integrity commissioner's activities, may summarize advice, but does not disclose any confidential information. And then there is a second type of report to council, and that is a report on a specific investigation or related to a specific investigation. And as I said, in that case, that report arises when there's a determination that a member has either contravened or not contravened the code of conduct. And in that case, any information that the commissioner determines is necessary can be included in the report. And so section 223.6 requires reports received from the integrity commissioner to be made available to the public. So these are specific reports, and so specific reports about a specific complaint are made available to the public. And that is different, as you may be familiar with the rules under MFIPA, where if there is any information dealing with an alleged wrongdoing, that information is protected under MFIPA. Under the part of the Municipal Act, there is actually an obligation to disclose this information publicly. Your municipality's complaint protocol provides that reports include the name of the member, but not the name of the complainant or witness unless the integrity commissioner just deems that to be necessary. Okay, so in terms of penalties, there are only two statutory penalties in the Municipal Act, and those are, first of all, that a council can impose if it's determined that a member has contravened the code of conduct. The first is a reprimand, and the second is a suspension of pay to the member for a period of up to 90 days. So that is the worst penalty that can be imposed for a code of conduct violation. And as I said, the integrity commissioner is making a recommendation on a penalty, but it's actually council who is imposing the penalty. In addition to the statutory penalties that are set out in the Act, the integrity commissioner recommend and council may impose remedial or corrective measures. So these there are a number of remedial or corrective measures, possible measures that are set out in your code of conduct, and they're in section 16 of your code of conduct. And these are things like requiring the member to provide a written or verbal apology, returning property or making reimbursement of its value or money spent, being removed from or not being appointed to membership on a committee of council, being removed from or not appointed as a chair of a committee, or complying with any other remedial or corrective measure deemed appropriate by council. Now that's some pretty broad language. We know from the Altman and Whitchurch-Stouffville case that other actions that would fall into this category that are imposed by council must actually be corrective or remedial and can't be considered punitive sanctions or penalties. So I will give you an example. A municipality close to Toronto, just outside of Toronto, called Whitchurch-Stouffville, is the mayor of that municipality. This was in the news. I don't know if you saw this news, but he had what was called in the media a CSI wall. It was a bit odd. Just off of his office, he had this room which had pictures of staff members and actually a lawyer from our office and various other people that were sort of like his hit list of, anyway, it was very odd. In any event, he was found to have violated the code of conduct and acted in a way that constituted workplace harassment as a result of this CSI wall. So that was the finding in the report. The sanction that was imposed by council was a ban on this member from attending any municipal facilities. Okay, fine. He threatened or said that he would maybe threatened to threaten members of staff. So maybe that makes sense, except he appealed this sanction because he wanted to be able to take his son to his swimming lessons. And to be able to do that, you need to go into a municipal facility. And the court actually agreed with the member and said that this was not an appropriate sanction. And the reason why in this case, like the court didn't take issue with the municipality's ability to impose remedial measures. What they looked at in this case was whether the measures were in fact remedial measures rather than a penalty or a sanction. And here it was the judge looked at the remedy that was recommended or that was imposed and found that it was actually a punitive measure, and so they were not able to impose that penalty. An example that would have been better in this scenario would have been something like sensitivity training, which does make sense. It is actually a remedial measure trying to improve the situation rather than just an outright ban in this case, which was found to be a punitive measure. Okay. So once council receives, will receive a code of conduct report, council is limited to dealing only with the penalties and or remedial measures that it is to impose. So that means when you're receiving a report from the integrity commissioner, this is not an opportunity to cross-examine the integrity commissioner on the investigation that occurred. The report that you'll receive, typically is pretty lengthy. It sets out the information that was received, the steps that were taken in the investigative process, and then the findings that were made by the integrity commissioner. And that's where we're explaining why we came to the conclusion or the recommendation that we did. So you have that in front of you as the report, and then it's up to you with those facts and that opinion to determine what recommendation you're actually going, or what recommendation you're going to adopt, or what the penalty or remedial corrective measure will be that you impose. So I would say to you that you have selected an expert, neutral professional to be your integrity commissioner. And part of the functions that you have assigned to me and to the others at my firm as your integrity commissioner is to investigate and prepare these reports and give this advice to you as counsel. And you should also be cognizant that I'm not a political animal. I'm bound by statute and by the common law to act fairly. So I want I'm sure you already know that, but I just want to highlight it again. That should be the approach in your mind when you're looking at a report from me. And then I also want to say that when council is determining what penalties or remedial measures to impose, council should be cognitive that they're performing an adjudicative function when they're making that decision, and so should strive to act with a greater degree of neutrality than when council is commonly dealing with other regular matters in a meeting. Okay. And this quote from the Toronto Integrity Commissioner's report in 2019 highlights some of what I was just talking to. You do not necessarily need to agree with every report and finding, but really focus your deliberations when a report is in front of you on what the appropriate penalty or remedial action will be in that case. And this is echoed in section 17 of your code and conduct. So to conclude this first part of our night, our training session, I want to highlight to you that on March 1st, we entered into a new era of municipal accountability and transparency. Now, all members of council and local boards will be subject to the code of conduct with some mandatory subject matters. We talked about that. Integrity commissioners have new broad authorities, including providing specific and individual written advice to members of council and local boards on the code of conduct as well as on the MCIA. And integrity commissioners now can investigate a complaint that a member did not comply with the sections of the MCIA, and that's a new function for integrity commissioners. So those are my conclusions. That's my presentation on the first part of this evening with respect to the code of conduct and my role as an integrity commissioner. Does anyone have any questions about this first part before we take a break?
Just more, how was Ayrton Burris and yourself remunerated, and who pays?
Yes, it's the municipality that pays for our services as you would any external consultant.
Thank you.
Okay, so let's take a 10-minute break. That means that maybe let's make it a 6-minute break just so that sorry, and here I've just put up my contact information. If you have any questions, my email address is there and my phone number, and I'm happy to answer any questions that you have this evening after the presentation, or tomorrow or whatever. So why don't we come back at 8:20? I'm cognizant that we are, I want to get you here, not late. Oh, sorry, 8:20 my time, that's 7:20 your time.
1 hour difference.
I know. I'm silly, I didn't realize there was a different time zone until I was actually there, and then it was very confusing with my flights.
Okay.
Everybody else screams like kids too. I don't know what to do. Good at it.
You're so dedicated. And you love But I had to come down.
Yeah, I realized after. So we need somebody to yell at everybody.
Yeah, I've done a thing about working. He told me that message would come.
You're texting I should put that on one of the TV.
Maybe I'll ask when we need help. Yeah, I'm sure. Yeah, we have fine, I'll follow up. You have to fly by the seat of your pants.
The meals are organized.
Yes.
Lots of forgiveness.
That's true. People are just happy to have their meal and then everyone socializes. Yeah, I in some high school students are you watching? Jenna
And the World Series.
Oh.
Are you a big baseball fan? Okay. Well, then you should just leave. Just sign your paper.
So I guess I should wear.
I understand.
I get it.
How are you keeping? What the other guy looks like?
He's in better shape.
Yeah, there seems to be a few gaps in the crowd. Yeah, she's waiting it. Oh, well, I was gonna give her the second. She was hiding stuff. Yeah, like no, I don't think. Yeah, just show up to work and when you're done, let us know. Yeah.
I'm enjoying being on council. I do like dry stuff, but not.
Well, sweet, sure.
I've seen a few closed eyes.
Well, I'm in a bad spot because I have to make sure.
Yeah. Yeah. Yeah, another 40 minutes or so. Yeah, no, it is. You'll need to know that there's a structure in place, protocol. Cross the line. So what we have to follow as council is extended to everybody that sits on yeah. Well, they've had issues before, right? So,
That's what I heard.
yeah.
There's usually a reason.
You probably don't get too many of the library bugs though.
No, it's only my second, this is my second meeting. It's supposed to be today.
Oh, okay. Yeah, because he's on the board. Yeah. And Joyce. I was going to be, but she wanted to be on that committee.
Yeah. I think it's a question.
Yeah.
Which one did you get?
Well, that's what I wanted to sit on.
Hi, everyone.
You haven't had a meeting? Oh, we haven't had a meeting.
Then I picked up one.
And I'm on the Nora board for Home for the Aged.
Oh, nice.
Yeah, so I got a meeting on Thursday. I have with Nora for.
You'll learn so much stuff. That's what I missed when I was starting to be. It was just interesting.
Yeah. No, exactly. There's lots. Yeah, it is. Business runs. Between my brother and I, it works out. I really enjoy it. So.
Hi.
Traffic tonight. Probably right before Christmas, so whoever wants to run. Thought it better to go back to the public for it since it's not even a year yet, right? Now if it was closer to running again, we would just appoint someone for a couple months. Just another 3 years.
See, I'm not very nice.
2, 3, 4 people. Yeah, it'll be a lot less. There won't be any meeting.
Yeah. A lot quieter.
What are you doing now? Are you?
Yeah, well, I'm in the guidance office this semester. I was permanent, but it was but I'm on a maternity leave coverage.
Okay. There's lots of work in this town. Never ending.
It's kind of nice to be back here and know that.
Yeah. Okay, yeah. Hopefully something just comes along and then you're good to go for the next 25 years. No, exactly.
You doing this or?
Don't a lot of people take that chance and
I guess
hopefully something comes up.
You're in charge. That's all you kind of does.
Family and friends. Yeah, it makes a big difference.
Okay, everyone, I think we'll get back to our presentation. Again, I appreciate everyone's participation, and I know it's a lot of material to take in, a lot of information to take in, and we appreciate attended this, and we will continue on. I'll hand things back over to Megan.
Well, it is because we have it in our.
Thanks, Brian. Can everyone hear me again? Thumbs up. Okay. Great. All right. Yes. And thank you for your attention. I know this maybe isn't the most exciting thing to talk about ever, but it's really important. And I want to make sure that you are, you've got the knowledge that you need if you're ever faced with a complaint. You can understand what the regime is out there and what's there, what your obligations are so that you're informed. And then also you can understand the scope of your obligation. So jumping in to talk about the Municipal Conflict of Interest Act, there were a number of changes made to the MCIA in this most recent set of amendments that came into force in March. Originally, the MCIA was enacted in 1972, and until this year really hadn't changed very much. It codifies provisions found in previous versions of the Municipal Act dating back to the Baldwin Act in 1849. So this is really an area of the law that from a statutory perspective has not changed much, but it's a very short act, but there's a lot of case law interpreting it. And the case law can be a bit tricky to navigate. So that's part of the reason why I'm here. There aren't any regulations under the MCIA, so if you pull it up, it really is only like a couple pages long if you were to print it out. The MCIA is applicable to members of council and also to members of local boards, which is defined more defined in Section 1 of the MCIA and is actually defined more broadly in the MCIA than it is in the Municipal Act. I don't know why the definitions don't match, but there you go. The Municipal Conflict of Interest Act does not apply to municipal staff, only to members, elected or appointed officials. So that is you. Now, the MCIA, I don't know if this is going to help get your attention, but the MCIA or contravention of the MCIA is one of the few ways that you can actually lose your council seat. So while under the Code of Conduct, the maximum penalty that you were looking at was loss of pay for up to 90 days. Under the Municipal Conflict of Interest Act, the penalties are much more serious. So the purpose of the MCIA is to prohibit members of council and local board from engaging in the decision-making process in respect to matters in which they have a personal economic interest. There is no need to find corruption on the part of the member or actual loss on the part of the council or board, so long as the member fails to honor the standard of conduct prescribed by the statute, then regardless of his good faith or the propriety of his motive, he is in contravention of the statute, he or she. Now, we'll unpack this a little bit more, but basically what this case from 1979 is telling you is that you need to follow the process that's set out in the Act. And I'm going to kind of give an overview of the MCIA and how to interpret the test and that sort of thing. And then I'm going to actually at the end walk through step by step what the process is to disclose a pecuniary interest so that you have that in front of you and it's a resource that you can take away too. So in order to take your seat at council, a member was required, you council members were required to solemnly promise and declare 4 oaths. One of those oaths was that you would disclose any pecuniary interest, direct or indirect, in accordance with the MCIA. Local board members and members of committees, even if you didn't swear this oath, the MCIA still says that it applies to you, and the obligations in the MCIA are personal to you. So you are the one that will be personally at fault if you fail to disclose a pecuniary interest in a matter. One of the new sections of the MCIA is a statement of principles in section 1.1. So you will recall that we went through the statement of principles in your code of conduct that weren't operative, but helped interpret the rest of the sections that followed. The MCIA now has a similar statement of principles at section 1.1. First of all, the importance of integrity, independence, and accountability in local government decision-making, the importance of certainty in reconciling the public duties and pecuniary interests of members. A principle is that members are expected to perform their duties of office with integrity and impartiality in a manner that will bear the closest scrutiny. And then fourth, is the principle that states there's a benefit to municipalities and local boards when members have a broad range of knowledge and continue to be active in their own communities, whether in business, in the practice of a profession, in community associations, and otherwise. So if we're looking at an alleged breach of the code of conduct, of the MCIA, then these are principles that we would refer to help be the lens through which we look at any alleged contravention. And I think number 4 is important to remember. I've just tried to scare you by saying the MCIA contravention is the one way you can lose your seat. But I think it's also important to recognize, and as is done here, that members of council and members of local boards and committees often have a number of pecuniary interests in their municipalities, which is a good thing or is not necessarily a bad thing because it shows deep roots and ties to the community. So the idea isn't to punish that. There's nothing wrong with the fact of having a pecuniary interest. It's just important that the member is not seeking to vote or influence the decision of council when such an interest exists. So when we talk about a conflict of interest, there's a common meaning and then there's an MCIA meaning. So the common meaning of a conflict of interest is a situation in which a person has a private or personal interest sufficient to appear to influence the objective exercise of his or her official duties as, say, a public official, an employee, or professional. So that's sort of like the dictionary definition of a conflict of interest. Under the MCIA, there's a very narrow and specific meaning, which is a direct, indirect, or deemed pecuniary interest, and we'll unpack all of that. But I have to say there is no definition in the MCIA about what direct or indirect means. So let's talk about that. Now, I'm pointing out the difference between the common meaning and the MCIA meaning because it's likely that your electors aren't aware, or the residents of your municipality aren't aware of the difference between these two meanings. So, I mean, that may be something that they can come and watch this presentation and be educated, or you yourself may be able to advise them. So from the Green and Borens case in 1985, we know that each conflict of interest case must largely stand on its own facts, and what constitutes a sufficient pecuniary interest to trigger the obligations under Section 5 of the MCIA will not necessarily, and in the language the court used in Cooper and Wanko, not necessarily be demarcated by a bright line. It's helpful, this new provision in the Act that allows you to seek advice from your integrity commissioner is helpful because we're here to help you interpret this legislation and the case law, which can sometimes be contradictory. And it's not always clear where that bright line or where that line should be drawn. As members, your MCIA obligations are engaged when you have a direct, indirect, or deemed pecuniary interest. So that the interest is pecuniary or financial only. We'll talk about direct, indirect, or deemed. The financial obligation can be a positive financial obligation, a gain, or it can also be a negative interest. If you suffer a loss, that's still a financial interest that you have, and the MCIA is still engaged, even if you are not gaining anything from voting, for instance, or voting against your own interests. That's not something that you can do. The other thing about the pecuniary interest, or the piece that engages the MCIA, is that an interest only arises, this section of the MCIA is only engaged when the interest arises in a matter that's before council or the committee for consideration, or before municipal staff for consideration. So we'll talk about the potentiality of an interest arising, and that can get a little bit tricky, but the matter for your obligations to arise under the Act, the matter actually has to be before you. So a direct pecuniary interest is one that expressly or unequivocally has an impact on your personal finances or property value. And it is a situation in which the member could experience an immediate, in the sense of close, non-deviated or traceable financial or economic impact, positive or negative. A potential interest, as I said, does not necessarily constitute an interest, but, and there's often a but in these cases, if it's a situation where even if the member will not do anything else, I'm trying to summarize what's on the slide, but I'm just going to read it. A potential interest does not necessarily constitute an interest, but where a party without further conduct on its part stands to have its financial position affected, a potential interest may be considered a pecuniary interest. So I'm going to give you an example of real estate agents. I mentioned real estate agents before. Are there any real estate agents in the room? Show of hands. I know. There are, I mean, I'm actually surprised that there's only one, because often there are lots. I guess it's like it goes well together. Anyway, so I get real estate agents come up to me all the time at the end of these presentations. Well, actually not since I started using this as an example, and saying, what about me? I sell properties all throughout this municipality, or maybe in one neighborhood in the municipality. This is my neighborhood. What if there is a zoning application, for instance, in this municipality? Don't I have a pecuniary interest because this is my business? And that's where I have to say it really depends on the facts of the case and how connected you are to the issue. And that's where we maybe need to have a conversation and talk about what matter is before council or before the committee, and what the nature of your business is, and the nature of this property in terms of your job. So that's where things can get a little bit tricky. But regardless, to say, keep in your mind, when I talk about a direct interest, that is about an interest that you personally have, okay? So an indirect interest is where you, the member, or your nominee, is a director or senior officer of a public or private company, is a shareholder of a private company, has a controlling interest in a public company, so that means more than 10%. If you're a member of a body, this one is challenging, because when we talk about member of a body, this is in the Act, but it hasn't been defined. But we do have case law coming from Dufferin County saying that when we talk about body should be broadly defined. So if you are a member of a volunteer organization, so for example, Rotary or Girl Scouts of Canada, then you should be cognizant that this section could, or your membership with that organization could engage in indirect interest in a matter. An indirect interest also exists if you're a partner or an employee for a company. So if one of these entities has a financial interest, so for example, if the restaurant that you work at as a server has a pecuniary interest in a matter that's before council, then you, the member, have an indirect interest in the matter pursuant to Section 2. So you should be aware of any relationships that you have that would fall under this category. Section 3 of the Municipal Act talks about a deemed interest. Now, a deemed interest is when you have a direct, you yourself, or when there is a direct or indirect interest of not just yourself, but also your spouse, a child, regardless of the age of your child. So my parents, even though I'm a grown-up, would have a deemed interest if they were a member. A parent those interests of those people are deemed to be the interest of you, the member. Now, the Section 3 sets out this specific list of relationships of close family members. I should point out that under Section 3, it doesn't include someone like an aunt or uncle, a niece or nephew, or a cousin, for instance. It really is limited to these relationships. I've interpreted this section in the past also to apply to steps, like stepson, stepmother, whatever. The one thing that is interesting and tricky about this section of the Act is the language that says if you're deemed to have this interest, if the interest is known to you. And there isn't any case law to interpret what known to the member would mean, but I think that it's fair to say that you should exercise appropriate diligence in understanding what the direct and indirect interests of these people are in your life. Plus, you could just like call up your kid and figure out what they're doing, right? Okay. So if you read any part of the MCIA, it's very short. But if you read any part of it, I encourage you to read Section 5 because that's the part that affects you directly, that sets out the obligations for you directly. Section 5 of the MCIA provides that where a member has a pecuniary interest in any matter and is present at a meeting of the council at which the matter is the subject of consideration, the member shall disclose the interest and the general nature of the interest prior to any consideration of the matter, not take part in any discussion and not vote, and not attempt to influence the voting on the matter in any way. You as a member are only required to leave the meeting at which a matter in which you have a pecuniary interest is being discussed if it's a closed meeting, but our recommendation is that you actually leave the room even if it's an open meeting so that you can't be accused of trying to influence the vote because that's one of the things that you're not allowed to do. And it could be that there's an accusation if you're making a certain facial expression or certain gestures that you actually are in fact trying to influence the vote. So just be cognizant of that. Better safe than sorry. Section 5.2 of the code is a new section that's just been included. In my office, we call this the Hazel-McCallion Amendment, and I'm going to explain to you why we call it that. Section 5.2 says that if a member has a pecuniary interest, the member is not only not permitted to vote or influence the matter at council, but also not permitted to use his or her office to influence any decision or recommendation that results from consideration of the matter. So this goes beyond the council meeting. This is behind closed doors. This is with staff. And this is the idea of influence. So the reason we call this the Hazel-McCallion Amendment is because it arose following a court case in which behavior of former Mayor McCallion was the subject of an application to the court. In this context, the mayor's son was a partner in a development company called World Class Development. And World Class Developments had proposed a major development project in the city of Mississauga, where the mayor was the mayor. In front of council, Mayor McCallion acted entirely by the book. She declared her pecuniary interest. She did not vote. She did not attempt to influence the matter at council. However, behind the scenes, she did promote the development project and did everything that she could to try to advance the project with staff. Now, an elector found out about this and brought a claim against her for allegedly contravening the MCIA, which she challenged. And Mayor McCallion, or her lawyer, argued that, in fact, Mayor McCallion had followed all of the rules in the MCIA to the T. And the judge in that case actually agreed. And he said, you're right. The MCIA, it's a closed, we consider this a complete code. So the rules, the obligations that are set in the MCIA, those are the ones that you have to follow. And you did, because you declared your interest. And so Mayor McCallion in this case was actually not found to have contravened the MCIA because there wasn't a provision in the MCIA that spoke to using your influence outside of the council meeting. Fast forward a few years later, and now we have this amendment that has been added, and that's why we call it the Hazel-McCallion Amendment, which expands the scope of the MCIA also beyond just what's happening at a council meeting. Okay. So the general rule under the MCIA is that you can't vote or seek to influence matters in which you have a pecuniary interest. I think you get that right now because I've said it like 6 times. So that's the general rule. Then there are a number of exemptions that are set out in the Act. So there are 9 specific exemptions and 2 general exemptions, and those are set out in Section 4 of the Act. So the exemptions or exceptions are listed in the slides here. The specific ones relate to if you as a member are a user of public utilities, you can still vote on a matter that relates to public utility, even though you are using the public utility. And it's sort of similar. The other examples are very specific. Another one relates to any allowance, remuneration, salary, or benefit that you may be entitled to. So for instance, you are entitled to, as a council member, vote on your own pay. Like that's something that you are entitled to make a vote for, because who else would do it if you couldn't? Then there are 2 general exemptions. J is if you have an interest in common with electors generally, and K is engaged when the interest is remote or insignificant. So these 2 general exemptions can be a bit tricky to interpret, and often case law can be helpful, but in this case, the case law is a little contradictory, so this is where it can be a little challenging to figure out what the obligations are. And so those I've just highlighted in red on the screen there. So let's talk about this a little bit. The first exception, having an interest in common with electors generally, that interest in common with electors generally is defined in Section 1 of the MCIA. And that means if you have a pecuniary interest in common with the electors within the area of jurisdiction, and where, and it also includes, so that would be like the entire municipality of Sioux Lookout, and also where the matter under consideration affects only part of the area. If you have an interest that's the same as other electors in that area, then it's considered an interest in common with electors generally. So it doesn't necessarily mean the whole municipality. It may, for instance, mean your neighborhood, but this can be really challenging to interpret, because what we're talking about here, is it a difference in nature or in kind of interest, or is it in nature and degree of interest? So one example, which has actually come up in lots of different municipalities over, time, is where a road or an LRT, for instance, is built in front of a house. If you own the house, do you have an interest in common with electors generally? What do you think? Nope. Okay, that's fine. You can participate later. So it's a tricky question, because If you are living in an area where there aren't very many people fronting onto the road, for instance, and there are like 4 houses fronting onto that road, then maybe yes, you do have your own independent interest and you don't have an interest of in common with electors. But if you are if you're living in a subdivision, for instance, and you're one of 40 or 100 other people who also front onto the road, then in that case, you may be able to take advantage of this exception. In one smaller municipality, I had a member come up to me after one of these training sessions and say, we are looking at approving a bunch of park improvements to this local park. They were putting in like a jungle gym and building a tennis court or something. And I own a rental house on the street where the park was located. So I said, okay, let's take a look. So I Google mapped to try to figure out where the house was, how close it was to the park, how many other houses there were in close proximity to the park. And in the end, looking at it, it was at the end of a cul-de-sac, this house and the park, and the house was only like 2 doors away from the park. And there weren't, it was a more rural municipality. This part wasn't rural, but it was, a smaller municipality. There were not that many other lots close to the park. And in that case, that we determined that council member did actually have, did not have an interest in common with electors and did have their own pecuniary interest that they needed to disclose. So that's an example of the analysis that we would go through to try to determine, look at the facts of each case and try to determine whether or not you can rely on this exemption. And another exception is the remote or insignificant interest exception. It provides that the relationship between the member and the subject matter must be so indirect or trivial that it leads to the conclusion that the potential personal gain was not a motivating factor in the member's decision making. So the test that we would use if assessing this exception is whether a reasonable elector, being apprised of all of the circumstances, would be more likely than not to regard the interest of the councillor as likely to influence the councillor's action and decision on the question. So one case where this exception was reviewed was in the Madger and Ford decision, which was a code of conduct case, which then, it was a code of conduct matter, which then became an MCIA case. And it relates to the City of Toronto's former mayor, Doug Ford. The Integrity Commissioner issued a report concluding that certain fundraising activities that the mayor had carried out violated the city's code of conduct for councillors. In this case, as you may have heard, Mayor Ford had solicited donations to the Rob Ford Football Foundation, and he'd done so using his mayoral letterhead. And these donations he'd solicited from city lobbyists and companies that were doing business with the city. Now, the IC in that case, in the code of conduct piece of the complaint, had recommended that the councillor personally repay the $3,150 in donations that he had managed to get from these entities and provide proof of reimbursement. So when this report went to council, the actual mayor spoke to the matter, and he defended his actions and explained how his charitable foundation worked, which you can't do under, we'll talk about this in a second, but under the old version of the act, that was not something that was open for him to do. And so someone made an application under the MCIA, and and saying that Mayor Ford had breached Section 5 because he'd spoken and tried to influence a vote on a matter that he had a pecuniary interest in, because of course the penalty in that case had been repayment of funds. Now in that case, there was the lower court said that Mayor Ford had contravened the MCIA, and then it was overturned at the Court of Appeal. But in any event, what's interesting with respect to the remote and insignificant exception is that at the lower court, and this is still like law that we can look at, because the way that the Court of Appeal overturned it was on a different point, so this is still relevant. But the determination on the remote and insignificant test, which is of course what Mayor Ford argued, because he said, I am a rich man, $3,000 is not a lot of money to me, it's insignificant. Justice Hackland at the Superior Court said, no, it's not, doesn't meet this remote and insignificant test, because this matter was important enough to you for you to stand up and speak to it at council. So if it was truly insignificant, then you wouldn't have made the effort to stand up in front of council and make your deputation. So in any event, I won't get into the details of that case, but that's an example of where the court actually assessed whether this was a significant matter. The other part of this exemption is if the matter is remote, and a test of remoteness looks at the immediacy and potential of the financial or economic interest. So it's not just that the financial value is low, like in the Madron Ford case, but it's also the distance from the matter. And then of course there's significance relating to the importance of the matter to the member, and we just talked about that case. So for the remote and insignificant test, we're looking at a two-stage test. If the matter is deemed a deemed interest or an indirect pecuniary interest. And we have direction from the court in the case Ferry v. Ontario Attorney General. And in the Ferry and Ontario Attorney General case, the facts were that Councillor Ferry was a member of regional council at the region of, actually maybe he was a city councillor at the city of Vaughan, and he had brought an application himself to court to determine if he had a pecuniary interest or if he fell under the remote or insignificant exception in the MCIA. Excuse me. And that's because council at that time was considering an official plan amendment that was really important to the municipality. But Councillor Ferry's son was a lawyer, a municipal lawyer, an associate at a law firm representing clients who had appealed the OPA. So because it was Councillor Ferry's son, Councillor Ferry had a deemed interest, and because Councillor Ferry's son was an employee of the company that was benefiting from the appeals of the OPA, he had an indirect pecuniary interest. So it was a deemed indirect pecuniary interest. I know it's like a pretzel, but that's what it was. So the court assessed this matter, and in this case, they actually determined that the council member did have the council members deemed indirect pecuniary interest in the matter was remote and insignificant. And the analysis that the court undertook in this case was they looked at the fact that this was the councilor's adult son who was an employee. He wasn't a partner at the law firm. He was an associate, so he was just an employee. They weren't his clients. He wouldn't get any personal benefit if he'd won or lost the case. There was no bonus tied to winning, for instance, and those types of factors are what the court looked at here. And so that it was on that basis that the court was able to determine that the council members' interests were too remote in this case, and he was able to take advantage of this exception. But as you can see, it's quite a fact-specific analysis that the court goes through or an integrity commissioner would go through. And I should also say, in the Ferry case, the council member himself had to pay to send an application to court to get this information. And an application to court, the court process is quite involved. Now, now as members of council, you can come to the integrity commissioner and get advice from the integrity commissioner and rely on that as advice, as I've said. And that can be in the form of a detailed email. It does not need to involve all of the filing of materials that previously you would have had to go through to get information from the court or a ruling from the court. So there is another new exception that's been included in this newest iteration of the MCIA. We call in my office this the Rob Ford Amendment, and it relates to the story I was just telling you about the remote or insignificant analysis in the Madron Ford case. And so under section 5 sub 2.1, if the matter that's under consideration by council or by the local board is about whether to suspend the remuneration paid to the member. So if we're talking about a suspension of pay, which is one of the penalties available under the Act, then for related to a contravention of the Code of Conduct, then you, the member, actually do have a statutory right now. Like, this is different than it was when we had the Madron Ford case. Now this amendment has been made, so you do have the authority to take part in the discussion of the matter. You're allowed to make submissions to council or to your committee. You are entitled to try to influence the voting, as Mayor Ford did in his case. And that is really about procedural fairness, to make sure that you do have an opportunity to speak to the matter that involves you. So whereas previously that was something that was not open to you to do, now it is something that you are entitled to do under section 5.2.1. However, you are not entitled to vote on the matter, but you are entitled to attend a closed meeting. And this, of course, this is just about if there's a monetary sanction, because we're only talking about pecuniary interest. So if you have a pecuniary interest, I mean, your pecuniary interest that you would have is the obligation to pay back the $3,150, for instance, right? Nodding. Yes, great. All right. So your duty of disclosure under under section 5 arises at the meeting at which the pecuniary interest is to be discussed. You must disclose the interest and the general nature of the conflict. Your absence from that meeting does not count as a declaration. If you are if you just haven't attended the meeting, you still need to declare or disclose the pecuniary interest at the next meeting at which you're present. So your disclosure needs to take the form of a written statement. And this written statement, which includes the nature of the interest that you're declaring, needs to be filed with the clerk or the secretary in your municipality. I think there's probably a procedure in place. Brian, yes?
Yes. Yes.
I'm assuming you're nodding. Thank you.
Yes, I am.
Can't see you, but I can hear you. Okay, great. Section 6.1 of the MCIA requires municipalities to establish and maintain a publicly accessible registry that includes a copy of each statement of disclosure and also to record each declaration in their meeting minutes. I heard you address that matter at the outset of this meeting, and I'm assuming that will be included in your meeting minutes.
It will.
Thank you, Brian. So the duty of disclosure, I mentioned this at the outset. You have a duty to disclose even if you are voting against your own interests. And we know that this is the obligation because of a 1978 case where the council member voted against a resolution approving a new arterial road to relieve traffic upon a street upon which he resided. It's those streets, they always come up. So even though the council member in that case voted against the resolution for the new arterial road that would have made his life easier and increased the value of his property, the member did not voted and therefore breached the MCIA because he didn't declare an interest and he didn't abstain from voting. So just be aware of that, please. We've touched on this a little bit already, and I told you I'd give you an example, and I will now. The ability to request advice from the integrity commissioner. So it is a statutory duty and responsibility of the integrity commissioner to answer and provide advice upon receipt of requests from members about their obligations under the MCIA. These requests for advice must be in writing. And when you're making your request for information or for advice, please ensure that you are disclosing all relevant information. So the example that I'm going to give you, I'm so sorry, is a recent case that I was not personally involved with, but I am aware of, where a member sought advice from the integrity commissioner, sent the request for advice in writing, as she was obliged to do, but she left out a very key fact, and that important fact changed the advice of the integrity commissioner. So the issue or the matter at issue was a zoning bylaw amendment that was being considered by the municipality that would permit silos to store grain in a certain area of the municipality. Now, the member reached out to the integrity commissioner because her husband is a farmer and owns farmland in the municipality. So she said, he's a farmer. Is there an interest that would engage my obligation to disclose? The integrity commissioner at first said, this is a secondhand story. I think he said at first no, but then got more information, and this was the key piece. In the planning justification report that had been filed by the proponent for the zoning bylaw amendment, and for the silos, the proponent of the silos had advised the municipality explicitly that the entity intended to buy grain from local farmers. So the fact that that statement was made in the planning justification report then engaged the member's interest, the deemed interest that her husband had as a farmer, as a local farmer, because now he had an interest in the silos being approved because he might have a business opportunity. So that's an example of where it's really important to make sure that you're aware of all of the salient facts and providing all of the salient facts. So this part of the presentation, I'm going to walk you through sort of step by step, the steps that you need to take when you're disclosing your interests or your pecuniary interests in a matter. So 5 sub 1 sub A of the MCIA provides that members must disclose any direct, indirect, or deemed pecuniary interest prior to consideration of the matter. The disclosure needs to include the type of pecuniary interest. Is it direct, indirect, or deemed? Sorry. And describe sufficient facts to provide some context for the general nature of the interest at hand. And that needs to be in writing. The second requirement is that the member is obligated to not participate in the decision-making process once the member's interest has been disclosed, which means that they can't take part in the discussion or vote. This is the rule, right? Section 5(1)(c) provides that a member declaring an interest cannot in any way attempt to influence voting, and that rule about not being permitted to attempt to influence voting relates to before, during, and also after the council meeting. If it's a closed meeting, section 5(2) provides that the council member must, that the member must exit the closed meeting. And as I said, this is a good practice to leave the meeting even if the meeting's not a closed meeting, because it visibly demonstrates that you are making an attempt to not influence the discussion or the outcome of the voting. A member is required under 5.1 to file a written statement of disclosure and its general nature with the clerk at the meeting at which the disclosure is made. So recall, if you're at the meeting, it has to happen then. If you're not in attendance at the meeting at which the interest arises, then the next meeting that you attend, you must make that declaration. Section 5.2, remember this is the Hazel-McCallion Amendment. You cannot use your office in any way to attempt to influence any decision or recommendation that results from consideration of the matter by an officer, employee, or other body. Section 6 of the MCIA provides that the clerk or board secretary must record in the minutes of the meeting, both the open minutes and closed minutes, if those are taken, the declaration of the conflict and that the member has left the meeting. If the member is absent from the meeting, you must declare at the next meeting, and the registry of written statements of disclosure needs to be maintained, and that's an obligation under 6.1. All right, so those are the steps. What happens with quorum? What happens if you go through all of these steps and you declare your interests and there are too many members that are precluded from voting to have your standard quorum? Well, Section 7 of the MCA provides for that eventuality. It states that where a number of members are disabled from participating due to the MCIA, the remaining number of members shall be deemed to constitute a quorum, provided such number is not less than 2. Now, I had flashbacks to elementary grade school math problems when I read this, but basically as long as you have 2, you can still vote. If it's less than 2, which means 1, I wasn't very good at math, but that I can do, then the council or the local board can actually apply to a judge for an order that council or the local board can consider the matter. So Section 8 of the MCIA deals with applications to court. So an application to a judge to determine whether a member has breached the MCIA can be brought by an elector. It can be brought by the Municipal Integrity Commissioner or by a person demonstrably acting in the public interest. Originally, the proposal had been with Bill 68 and these amendments that it could be any person who could bring the application, and this was amended. But what's interesting to think about, and I just throw this out there because I don't know the answer, is whether a person demonstrably acting in the public interest would also include a municipality. Because previously there were, in the old version of the Act, there was question about whether it was up to, whether it was open to municipality to make an application to make an application to court about an alleged contravention. So there is a limitation period on applications. So the application can only be made within 6 weeks of the applicant becoming aware of the alleged contravention. And so if it's, when we talk about became aware, that means that it's possible that the event could have occurred more than 6 weeks ago, but it's up to the applicant to prove that they only had the knowledge or only became aware of the incident within the 6-week period. So that is your onus if you are the applicant, or if you, whatever, to prove that you only became aware and why within that period. And the test that we're looking at there is whether is based on a reasonable subjective belief of the contravention. So so there's also an ultimate limitation period. So remember, even if it only came within your knowledge in the last 6 weeks, if the event happened 6 years and a day ago, then you are precluded from making an application based on the contravention. And this is typical. We have this in the Limitation Act, for example, if you have a slip and fall accident, or if you hire a contractor and they do bad things to your house or a bad job, there is a limitation period on how long you have to bring a claim against them. And that's the same in this context. And this is all about fairness and making sure that you don't have it hanging over your head forever, right? So one of the new amendments to the MCIA is the imposition of an election blackout period. So the Integrity Commissioner is not entitled to bring an application to a judge with respect to an MCIA contravention during an election period. An election period is defined as the period between nomination day and election day. And this was an amendment that was added to Bill 68 later on during the Standing Committee consideration. And that was at the request of council members who were concerned about these applications being used as a political weapon during elections. But I should note that this exclusion only relates to an Integrity Commissioner's ability to bring an application. It doesn't apply to an elector or a person demonstrably acting in the public interest bringing an application. Now, if I'm an Integrity Commissioner and I'm investigating an alleged contravention of the MCIA, then the requirement is that I terminate my inquiry if it hasn't been completed before nomination day. Now that inquiry can recommence after election day, but it's pens down, as one of the partners I work with likes to say, and I like to hear, between nomination day and election day. So the way that this system is set up under section 223.4.1, you can tell lots of amendments have been made to a piece of legislation when you're getting into the 0.4.1s of the Municipal Act. The way that this process works is that a complainant will make an application to the Integrity Commissioner about an alleged breach of the MCIA. Then the Integrity Commissioner will complete an inquiry, and there's a time limit on how long the Integrity Commissioner has to complete this inquiry, and that's 180 days. So after the Integrity Commissioner has gone through the inquiry process, which may involve getting written statements from people, it may involve interviews, it may involve looking at records, then it's up to the Integrity Commissioner to decide whether to, take it up to the next level and actually make an application to court under Section 8 of the MCIA. And it will be the municipality's responsibility to pay the costs of that court application. So this is different than before, when it would be individual electors or members of council, for instance, who would be bearing the cost of the application to court. Now, under the statute, it's actually the municipality that bears that cost. This is the new system. Someone was asking about who pays. This is under the MCIA and under the Municipal Act. This is who pays for this. So you can think about the inquiry to the Integrity Commissioner as being sort of a first step review to assess the merits, I guess you could say, of the complaint, or there's a word that I can't think of right now. Let's leave it at merits, or likelihood of success, or grounds of the complaint. There you go. There's a word, I'll think of it. In the shower or something, right? Or like in the middle of the night tonight, I'll be like, that's the word. So the penalties for contravention are set out in section 9 of the MCIA. And this is relevant, or I want to draw your attention to this in particular, because there have been an expanded range of penalties included in section 9. So any of the following penalties are open to the court to impose. Before, it used to only be removal from office, disqualification for up to 7 years, or restitution of any personal financial gain. These three old or original penalties were made the MCIA sort of a sledgehammer of a piece of legislation. And sometimes the breach would be relatively minor, and the court would be in a situation, and this is probably why we have some weird decisions coming out of the courts with respect to the MCIA, because the court may be in a position where they say, yeah, we do think that you contravened, but we don't think it's worth removing you from office, or even worse, removing you from office and then disqualifying you for up to 7 years. So what the legislature has done in this new amendment is included 2 additional penalties that are open to the court to impose, and that includes a reprimand and a suspension of remuneration of up to 90 days. So the court now has a better range of penalties to impose, which makes it a more useful tool instead of what was previously described as the draconian tool that was open for the court. So as of March 1st, in exercising his or her discretion to impose a penalty, the judge also has more considerations that he or she can consider, or more matters that they can take under consideration when they're determining whether or not to impose a penalty on a member. And those are set out in section 9 sub 2 of the Act. The new penalties are in the new considerations are in red on the screen. The first is that the member took reasonable measures to prevent the contravention. And the second relates to this written advice piece that we've been talking about. So the second is where the member disclosed the pecuniary interest and all relevant facts known to him or her to an integrity commissioner in a request for advice. And this part is kind of, self-explanatory, but still got to say it. The member acted in accordance with the advice given by the integrity commissioner. So that's something that the court, or would be open for the judge to take into consideration, which is part of the reason why it's good that you have this ability to seek advice, and why it's important to actually follow the rules about seeking advice. And then, of course, the consideration that has always been open to the court to consider is if the contravention occurred through inadvertence or by reason of an error of judgment made in good faith. Section 11 of the Act provides a narrow as of right appeal to the divisional court from an order of the Superior Court based on the application. So the order, the right of appeal only arises if the court has actually made an order and found that there's been a contravention. Only in that situation is it open to the member to then appeal the court's decision. Okay. So what happens if there has been a contravention found on a matter that you voted on? So the matter is not, or the member's failure to disclose or to comply with their obligations under Section 5 of the Act, that in and of itself does not invalidate the proceedings or the matter that was voted on by council or the committee or board. But it is up to that body to determine if they want to void the proceedings. So the proceedings are voidable, which means that a decision can be made to void the proceedings. However, there is a limitation on this ability to void the proceedings, and that's a time limit, 2 years from the date of the passing of the bylaw or resolution. And then the second limitation is that a proceeding cannot be voided if to do so would adversely affect the rights of any person acquired under or by virtue of the proceedings, and if that person, of course, acted in good faith and without notice of the failure to comply. Now, that's it in terms of substance. So to wrap up, things for you to remember. A conflict of interest under the MCIA is not nearly as broad as the general public likes to think it is. So we looked at the definition of a conflict of interest in sort of general parlance, and then the narrow definition under the MCIA. So it has to be a pecuniary or financial interest. That part is really key. There is a positive personal duty on members to declare their interest. There are also, as we saw, a large number of exemptions. We looked at the exemptions under Section 4 and also the exemption that Rob Ford Amendment under 5 sub 2.1. There are significant sanctions that are at play here if a member is found to have contravened the MCIA, which includes being removed from their council seat and being precluded from running or from holding a seat for up to 7 years. There are, however, saving provisions as long as the member has taken reasonable steps to prevent the contravention. For example, following the written advice of the Integrity Commissioner, or if the member has acted inadvertently or by a good faith error in judgment. And as I mentioned a couple of times through this presentation, there's a lot, it's a short statute, but there's a lot of case law interpreting the different sections of the statutes, and this case law unhelpfully can at times be contradictory. So if you're faced in a situation where you're not sure, just that's where I can help. So that's the end of the presentation. Does anyone have any questions?
I've noticed that Mayor Ford had lots of influence on this act.
Well, just that one amendment. But then, of course, there is that one decision. I know. Sometimes I feel badly to bring up those examples, but we try to spread it around the province. Was that a question?
No, just statement.
Fair enough.
Yeah.
Yes.
If you're in the middle of a meeting, in most meetings, a conflict of interest is declared at the beginning of a meeting. If you're in the middle of a meeting and something comes up, what do you do? Do you just get up and leave, or do you put your hand up and say, I got a conflict, and leave, or?
Yeah, that's a great question. So your obligation to disclose your interest arises as soon as you realize that you have an interest. So it is appropriate, and sometimes, to my great chagrin, this happens. You'll look through council meetings, and then the members' pecuniary interest will be buried on page 5, because it was only on page 5 of the meeting minutes that they realized that they had the pecuniary interest. So that's fine. I don't know if you have a specific process in place at your municipality, but certainly the obligation on you is to, I think we're going to get an intervention. Great. Certainly the obligation on you is to disclose as soon as you realize that you have an interest, not to get up and leave the room, because remember, even if you're not in the room, you still need to declare, right? So being absent isn't sufficient. Great question. Thank you. Anyone else?
I hate
Yes.
to give you a what-if situation, but I'm going to. So I currently
great.
been appointed to the Environmental Committee with Municipality of Sioux. We deal with, we discuss recycling program within the Municipality of Sioux. I'm employed by the company that collects the recycling for the Municipality of Sioux. I believe they're under contract. Do I have to declare a conflict of interest? Am I in conflict of interest when discussing at the environmental committee? I don't know. It's a lot of stuff you covered, right?
Yeah, so I have to say, first of all, I couldn't hear everything that you were saying, so I missed parts of it. What I did hear, I don't think was enough to actually give you advice on it, but I would encourage you, like we can talk about this offline afterwards if it's a specific example, but certainly when it's your like if you're an employee of a company and the company that you're working for, and this is where I didn't quite hear all of the facts in this case, but if the company that employs you has a financial interest in a matter, like a contract, for instance, that they're bidding on, that the council or the committee is considering, then you would have an indirect interest in your your employer's interest would be your interest in the matter. So I didn't quite get all of the facts, but that's the sort of the general framework to look through. But if you wanted to talk through any of the specifics, I'd be happy to do that. Or if there is I wasn't sure if there was like a specific matter before the committee, but if there is, that might be something that you want to send me an email about.
And we won't take up any more of the committees or this group's time. I would like to discuss after or by email, whatever.
Great, happy to do that. And hopefully my answer kind of gives a little bit of a framework. It's something that you need to get used to doing this analysis. I know that it can be a little scary, but just sort of look at the slides that we've given you, think about sort of the rules and how they would apply, and hopefully tonight what we've given you is a framework and an ability to sort of start to do that analysis on your own and understand what the rules are. Because it's not that easy to follow the act. It doesn't have that much information on it. So hopefully this is a good resource to help you kind of understand the analysis that you should be doing with your own interests.
Just one piece of information that would be relevant in this case. The committee we're talking about is an advisory committee. It's not a decision-making committee. That committee does not vote on whether or not that company gets a contract. That committee does not vote on the type of recycling program the municipality offers. So the committee is advisory in nature, and I think that may be relevant in any future conversations you have.
Okay, that's helpful. Thank you. Can I just say on that basically the role of the committee is to try to get people to recycle. So we saw the education about recycling. I guess you could argue that that increases revenue, but that's not.
So that's when, I'm sorry. I think, in this case, I would be looking at that Hazel McCallion amendment if we're looking to advance certain people's interests or certain companies' interests with staff at like a policy level, or if we are, if there is actually a matter for decision in front of council, right? Like where it's like, I don't know if there's a specific contract at issue. That's sort of, anyway, let's talk about this offline, but these are sort of the things that we would have to understand to be able to give you advice. So I think it's good. It's always fun when you're in my seat to get examples like that on the fly, but I think it's also good to kind of talk through what the analysis would be so you can see some of the questions that I might be asking you. Because if I don't have enough information from you, expect an email back from me asking clarifying questions. So please try to give me enough time to look at your email, think about it, ask a follow-up question or two, because I've noticed council meetings tend to be on Monday evening, and then those questions that come in like Monday morning, Friday night, which is always fun, which is totally fine. But it's if we can have time to kind of think about it and get the information, that's always the best case scenario. So as soon as you think you might have something, please let me know. Does anyone have any other questions? I'm not going to be able to point. I mean, I was going to be like, thank you, Brian.
I'm a member of the Silicon Public Library Board. My question really is to the municipality. Is there going to be any effort, or has there been any effort on the municipality's part to do cost recovery for services that are, say, perhaps engage the Integrity Commissioner by a board?
I can speak to that if you'd like, Mayor Lawrence. There is a lot of debate on whether or not municipalities should be charging people to file integrity commissioner complaints. I think that's where you're going with this. And the reality is some municipalities do charge people if they want to file a complaint with the integrity commissioner with respect to a code of conduct or MCIA matter. The general belief in the sector, at least currently, is that in the same way that if you want access to information and you file an FOI request, the fee is only $5. And the idea behind that is so that everybody has fair and equal access to that system. The same philosophy applies to, at least currently in the general realm of thought, to integrity commissioner services, that the general public should have a right of access, and cost shouldn't be a barrier to accessing that service. Now, not all 444 municipalities in Ontario feel that way. Some municipalities charge a nominal fee, like $5, like is required for the Freedom of Information request. There are some municipalities, when they felt that they were starting to get a string of frivolous and vexatious complaints, there are some municipalities that charge up to and over $500 to file an integrity commissioner complaint. So, but again, those circumstances are typically related to situations where they're just getting frustrated with frivolous complaints.
So thanks very much, Brian. That's really helpful. I don't think if that was the question, I can certainly answer that as well. But that was a perfect answer. So thank you. We act for some municipalities where they have imposed a fee for filing. Typically, it's something that it's open for council to decide to do that. But as Brian has said, the intent is to make filing an application open for everyone. And of course, $100 to one person, for example, as a fee for filing is a different kind of barrier than for other people. So it's something to consider. Most of our municipalities do not have a fee for filing complaints. I should say on that topic that a lot of complaints that we receive, and especially if they're frivolous and vexatious, do get dismissed. So if there are not grounds to have a full investigation, that is something that we are comfortable doing, because part of our role is to make sure that we're not wasting the municipality's resources, and making sure that we are there to investigate and able to investigate when an investigation is actually warranted. So the range of what a complaint can look like, or the way that we deal with a complaint can look like, is a letter dismissing the complaint without even providing a copy of the complaint, for instance, to the member, and that can be dealt with in short order. And then, of course, there is a big range that can go all the way up to a very large investigation. I myself have only been involved in 2 instances where a big investigation took place, actually maybe 3. Well, I mean, where we were actually going to the municipality and interviewing and doing like a multi-week thing. that is not that common. Typically, we're able to use other things like doing interviews by phone and only attending when it's really necessary to judge witnesses' credibility, for instance, where it's hard to do that over the phone. So there's a range, and that's one of the reasons why it's good, I think, not to toot my own horn, but it's kind of not just me, it's the team that I work with. We have a lot of experience doing this, and with that experience and also with working in a team, that's where the judgment piece comes in and the experience comes in, and where we're able to tell where it's actually worth it to go ahead and do the full investigation and understand and think through what we've got in front of us. So there is that is a step in the process that certainly happens at our office, because we're cognizant of some, like there are some frivolous and vexatious complaints that are filed. Sometimes you see the same people filing complaints again and again, and we're aware of them. They're coming to us. And we're neutral in every situation, certainly, but like we're not out there to rack up fees. I'm going to say that. Does anyone else have any other questions? I feel like that was like a big silencer. Sorry, guys. If you do have any other questions, I'm here. Happy to answer any questions. I think probably it makes the most sense. If people have questions right now, I can, maybe we can have a call. I know that sometimes the question comes to you right after a meeting like this, and typically I would kind of hang around and we could have a conversation. So I will be back in my office in 10 minutes, and then I'll be available for like the next half hour maybe if anyone wants to give me a call. And we can do it that way. My phone number, my direct office number is on the slides. Or of course, it is open to you if you are seeking any advice that you want to rely on, which is how I would encourage you to do this, to send me an email. So thanks very much for your attention tonight. I'm so sorry that I've gone a little bit over time, but I appreciate the questions and the attention.
Thank you very, very much, Megan, on behalf of everyone in this room. Very interesting presentation, lots of information, lots of knowledge shared. So thanks so much, and I will turn the meeting back over to Mayor Lawrence.
Thank you. Thanks, Brian. Thank you, Megan, very much for that. Thanks, everybody, for coming. We can do this two ways. I can give you 2 minutes to clear out if you want to go.
Thank you.
And get out and be gone so we can finish the meeting, or you can sit quietly for 5 minutes, 10 minutes. Okay, 2 minutes. Thank you.